Good morning, everybody. Thank you all for joining us. We've got a couple folks still making their way in from the waiting room. And I'm going to go ahead and get us started with some Zoom housekeeping tips for the meeting today. The first of which is that if you could please stay muted during the Zoom today, unless you want to unmute to ask a question, that would be great. Just cuts down on background noise and makes for a better recording after the fact. Speaking of the recordings, please don't get mad at Chelsea because the last couple are not up on the YouTube channel yet. That's my fault. We're working on getting those up this week. So please be patient with us, but we are working on it. Other Zoom housekeeping reminders are that your audio and video buttons are on your Zoom toolbar, wherever that is on your screen. It might be flashing right now because the chat button might be flashing. I just put a message into the chat. The chat is the best way to ask questions today, and we do not have a ton of pre-submitted questions, so feel free to pop questions into the chat. We're likely to have time to get to a couple of them at least before the end of our meeting today. The message that I put into the chat also tells you how to submit questions in between Zoom Q&As, and we're going to have a particularly long break this time because next week and the following week we are not doing the Q&A because both of them fall the day before federal holidays. So we are not going to do a Q&A on December 24th or on December 31st. So we are taking a 2-week break, and we will see you all back here on January 6th, I think. Hopefully I got that date correct. So don't come next week or New Year's Eve because we won't be here. And I hope you all enjoy a great holiday break. And I'm going to go ahead and continue with our normal announcements by reminding everybody that we are here to talk about general legal information, not to give legal advice. So we got several questions this week that went into great levels of specifics and details, and I had to tell Chelsea to email the folks that submitted those questions that they were too specific for us to cover in this Q&A. This is not a forum in which you can get legal advice. We can only give legal advice to associations that are our clients, where there's a fee agreement in place, but most importantly, also where we know all the contents of their governing documents, we know which statute they're governed by, all of those things. Not to mention the fact that a public forum like this is not a great place for attorney-client privileged communications. So no legal advice. That means if somebody sends you one of the Q&As or a blog article or whatever, and they try to tell you that you have to do something or you can't do some other thing because Jennifer said or Valerie said, you can ignore that. And if anything that we say here does make you question, oh, like, are we doing this right? Maybe we did that wrong. Certainly reach out to your association attorney and ask for actual advice for your community. And if you don't have an association attorney, this is my, semi-monthly rant about enthusiastic commentary about how important it is to establish an attorney-client relationship when you are not in the middle of a crisis. So if you don't have an association attorney, and you might think, well, why would I ever need one? I don't want to sign up with an attorney now. There is no cost to establish an attorney-client relationship with an association attorney. And if you do that now when you don't need one, then when you get served with a lawsuit or when the neighbor's tree falls on your property or somebody sends you a demand letter about the fence that fell over between you and the neighboring community, whatever the case might be, whenever you are put into a situation where you need an attorney and, maybe relatively quickly, depending on the level of urgency, you're not scrambling to find one then because you've already established that relationship now. So something to keep in mind. All right, I'm going to get off that soapbox now and keep going through our announcements. I already covered how to submit questions during the chat today, so I'm not going to recap that. If you do want to unmute yourself to ask a question verbally, though, we are fine with that. Just otherwise stay muted. I already reminded you we're not doing the Q&A next week and the following week. The last sort of general reminder is that we have been telling folks now since July, since before July, when the legislature passed the bills, that some changes to our governing statutes are taking effect on January 1 of 2026. There were some changes that took effect for already existing Wakaiowa communities in July when the bill became law, but all communities in Washington state, no matter what statute you're governed by, have a couple of changes coming on January 1 of 2026. One is that all communities are going to be governed by the meetings provisions within Wakaiowa, which means that whether you're an HOA Act community, an old Condo Act, or a new Condo Act community, you are going to need to look to the meetings provision of the Wakaiowa statute starting January 1 of 2026 and follow those rules about your meetings in your community. And the biggest change for a lot of communities is going to be that you are now all required to hold open board meetings with an owner comment period at the beginning of each board meeting. There are specific rules within the statute about what that comment period needs to look like. It can be limited to 15 minutes, but it needs to be no less than 15 minutes. And there's rules in the statute about how you divvy up that time between the owners that sign up and want to comment during that period. And the whole point behind this is the legislature and stakeholders in the room kind of looked at each other and said, like, what's the point of an owner comment period if it doesn't happen until after the board is done voting on all of its business for the day? It's not a meaningful opportunity for owners to comment if they're commenting after the board has already voted on everything. So that is why the comment period has been moved to the front end of the board meeting rather than the end of the board meeting, as a lot of communities used to do. So if you are in a community that has not previously held open board meetings, you are now required to do so. Another significant change for communities that have not previously been governed by this statute is Wakaiowa has, since its inception in 2018, limited the types of decisions boards can make outside of an open board meeting to ministerial decisions only. And what that means is that if you have a history as a community of your board operating primarily via email, like voting on a lot of things and only meeting maybe quarterly to kind of rubber stamp those decisions and put them in your minutes, you will no longer have that option. All substantive decisions made by the board must be made in an open board meeting when notice has been sent to the ownership at least 14 days in advance of the meeting. So what this is going to mean for a lot of communities that are new to this is that you're going to need to schedule more frequent board meetings. And in the beginning, it might be both more frequent and longer until you kind of get a little bit of experience under your belt for how things are going to go. But ultimately, the end result should also be more streamlined board meetings as you get practice for how to conduct an efficient board meeting. And the more frequently you meet, the less business you'll need to do at each meeting, right? Because you're not saving up 3 months worth of decisions for a quarterly meeting. The other thing that I will note is you can, and most of our communities, our clients are choosing to adopt an annual board meeting schedule that they send out once in advance of the year. So like in December, they're sending out a notice that says, for 2026, we are meeting on the second Tuesday of every month at 7 o'clock in the clubhouse or at the library in this meeting room or whatever. This is our general agenda for those board meetings. What that does for you is it eliminates the need to send out an individual notice 14 days in advance of every single board meeting. I will offer that you don't have to give the same amount of notice to cancel a board meeting. So we have some clients that are scheduling lots of board meetings and then giving themselves the option of canceling them when there just isn't enough business to warrant them meeting every time. You do want to notify your owners if it's canceled, right? You want to send out an email blast, a letter if that's not cost prohibitive for your community, maybe posting on your community association website or Facebook page or whatever. But you don't have to give the same amount of notice to cancel a board meeting as you do to conduct a board meeting. So keep this in mind. If your community in particular has a history of making board decisions by email, that is not something that's going to be available to you anymore for substantive decisions. We do have some clients that are choosing to adopt certain types of policies that delegate smaller decision-making authority to either the manager or to an individual board member so that there's clear authority for those smaller decisions to be made in between open board meetings. And I guess since I said the words in person, I will note that board meetings do not have to be in person. They can be virtual. And if you hold them virtually, you need to also provide a call-in phone number on the meeting notice in order for the meeting notice to be valid. So that's one of the big changes that's starting in January of 2026 for a lot of communities. The other shift in 2026, and this is again for all communities in Washington state, is that there will be new requirements for delinquency notices that must be sent to owners, and there will be limitations on collection options and penalties available to you until you send a notice that complies with the new statutory requirement. So I'll very briefly recap the requirement, which is just that within 30 days of an account becoming delinquent, you have to mail to the owner a notice telling them that their account is delinquent, giving them information on how much they owe, including a copy of the statutory pre-foreclosure notice of delinquency. And that notice has to be mailed to their mailing address if they don't live within the community, to the unit or lot address within the community, even if you know they don't live there. And you also have to email them a copy of it if you know their email address, even if they have not opted in to receiving electronic notice. So this is a really unique one in that the notice requirements are different than for almost any other kind of notice that you have to send to your owners. In addition, one thing to be aware of is that until you have mailed a notice that complies with the new statutory requirement, you are limited to charging one late fee that is no more than 5% of the unpaid assessment, or $50, whichever is lower. And you are limited to charging one admin fee of up to $10, no more than that. And you can assess the actual costs of mailing the notice to the owner. But until 15 days after you've mailed the notice that complies with the statute, you cannot do anything else in terms of penalties, monthly late fees, interest charges, management fees, referring to the association attorney, recording a lien, none of it. You have to put the owner on notice of their delinquency in a manner that complies with the statute and wait 15 days before you can do anything else other than one admin fee of $10, no more than $10, one late fee of no more than $50 or 5% of the unpaid assessment, whichever is lower, and then actual costs of mailing. There's a question in the chat about which statute covers these delinquency notice requirements. I don't have all of them memorized off the top of my head, but start with RCW 6434-364. That's the delinquency provision within the Condominium Act, and the language is mirrored across all of the acts. The other thing you could do is just Google your governing statute, RCW 6438, 6432, 6434, or 6490. Google your statute plus delinquency notice, and it will take you to the section of the statute that has these new requirements in it. There's another follow-up question in the chat. One admin fee altogether or one admin fee per month while the account is delinquent? And once you have sent a delinquency notice that complies with the statutory requirement, you can charge normal, reasonable notice charges that are allowed under the governing documents for the community. And that could include admin fees once you've sent the required delinquency notice. But until you have sent the required delinquency notice and waited 15 days, you're capped. Your maximum is that you're allowed to charge one late fee, one admin fee of no more than $10, and the costs of mailing that notice, and that's it. So the ongoing charges, once you've sent the notice that's required by the statute, you can do what you have always been able to do, but only once you've sent that initial notice that complies with the statute. Hopefully that answers the question. I think that's where I'm going to leave it. We'll kind of keep an eye on the chat in case there are follow-up questions about these things, but I'm going to let Jen jump us into our first question that was submitted in advance, and then we'll come back to the chat for more questions if we have time at the end. Oh, you're muted, Jen.
Sorry, cats were doing World War III. So the first question is, when initiating collections, what identifying information is permissible for documenting the board's decision if our software does not provide an account number? For example, may we reference the lot number, parcel number, or other property identifiers? The short answer is yes. You can use whatever identifier you want to identify what unit or lot that you're discussing, as long as the board and management company understand which lot is being addressed. So nothing prohibits, there's no statute that prohibits the board or the management company from just using a name. So, especially when we're talking about delinquencies or foreclosures, the statutes don't prohibit you releasing that information. But that said, we recommend against purposely using an owner's name in an attempt to shame them into paying for a delinquent account for multiple reasons. Shaming someone or trying to, or allowing other owners to harass or discuss a delinquency with an owner doesn't work to bring people current. It harms the relationship between the association and the delinquent owner. The relationship needs to be functional for the duration of the owner's how long that particular individual lives within the community. Most people think that delinquencies need to be are required to be discussed in executive session. 6490-445 is where the meeting statute is, and that's where all of the new meetings requirements are located as well. But specifically, subsection 2 discusses executive sessions, and delinquencies aren't necessarily one of the topics listed that has to be discussed or could be discussed in executive session. But even if you discuss delinquencies in executive session, the vote has to happen in an open meeting. So executive sessions are just for discussion. Any vote regarding that discussion has to happen in an open meeting. So in a nutshell, you can use whatever identifier that you want to discuss a particular lot or unit when they're delinquent. You don't have to redact or use another identifier. You can just use the name. It just could lead to more problems. So we recommend using some sort of other identifier as long as the board and management company know who's being discussed. Valerie, did you have anything to add to that?
No, I think that covers it. I will move us on to our next question, which says it's related, talks about the disclosure of delinquency information. The question says, if a community member requests to know which lot or owner is delinquent, what information, if any, is legally permissible for the association to disclose? So as we've already briefly alluded to, but I'm going to back up and say the short answer is that the answer to this question is not super clear because there are competing statutory provisions that can be used to bolster your position either way. So you can use one part of the statute to suggest that you should not disclose unit specific delinquency information or lot specific, person specific. And you can use other sections of the statute to support the position that delinquency information does need to be disclosed when an owner requests to review it. So until a court decides which of these provisions is more important or controls in this scenario, or until the legislature clarifies, we don't always have a clear answer to this question. And I think part of my question, if I had a client come to me asking me this, would be who's asking, what's the context, what is the purpose of their request for this information? So an owner asking a verbal question sort of as part of a larger discussion in a board meeting might engender one response, where an owner who's requesting an opportunity to review association records might engender a different response. And I'll tell you the different statutory provisions that we were looking at when we were discussing this question, because on the one hand, RCW 6490-495 subsection 3 requires that when an association is disclosing records to an owner, they should redact or not disclose an individual unit owner file to another unit owner. And we think for sure that this could clearly be used to say things like, we're not going to give you copies of the delinquency notices sent to, Mr. Smith, the next door neighbor. We're not going to give you copies of the violation notices that we sent to this neighbor. We're not going to send you copies of the communication between the association and that other owner. So non-disclosure of an individual owner's file clearly covers those things. The question that we have is, does that extend to redacting owner-specific information in general association records? So, for example, there is very clear statutory authority that says unit owners have the right to request an opportunity to review association records as they're kept in the ordinary course of business. And that would include things like delinquency reports and financials and balance sheets and other information that might include delinquency information that could reference a unit owner by name. Does the requirement to keep an individual unit owner file private from other owners extend to scrubbing that unit owner's name from general association records? I don't think so, but again, that's my educated guess based on a lot of information, 18 years of practice, sitting on the legislative action committee, et cetera. But I'm not a judge, and I don't know how a judge might rule if this were to come in front of a judge. If a association decided to either disclose or not disclose, and that ended up in litigation at some future date. So I think we can't give you a one size fits all answer to this question. It depends on a lot of things. Who's asking? Why are they asking? What is the context? And part of the answer might also come down to the board deciding and weighing the risk associated with disclosure versus the risk associated with refusing to disclose, depending on the scenario. So I know that's not as clear an answer as I wish I could give you, and as most people would like me to be able to give in response to a question like that, but I think it's the best that we've got. Jen, did you want to add anything to that?
Just when you have a question like this, please ask your association attorney. I know we get a lot of questions where even our clients will submit a question to the Q&A hoping to have it covered, and then when we tell them it's too specific, they don't ask us to actually answer the question. So just a reminder that bad facts make bad law. And if you have a question like this, contact your association attorney. Don't take on that risk without consulting legal counsel. Okay, moving on to our next question. Okay, so this is mailing requirements for properties without mail receptacles. We are required to send the notice via email and to all addresses on file. However, we manage two associations where the physical property addresses do not accept mail, and all owners use off-site mailing addresses. There are no mail receptacles on the property. In this specific scenario, are we still required to incur the expense of printing and postage to mail notices to a property address that we know does not receive mail, or is sending it to the off-site address and via email sufficient for compliance? So for most association notices, you can and should only send notice to the owner's mailing address. For the newly required first delinquency notice, and this is the changes in statute that are taking effect in 2 weeks, basically, it must be sent to the unit lot address, to the owner's off-site address, if any, and to their email address if it is known to the association, even if they haven't opted into receiving electronic notice. So the specific statute is 6490-515 sub 2 sub B, and I'm just going to quote it. Notice in a tangible medium, meaning paper, to a unit owner or occupant must be addressed to the unit address unless the unit owner or occupant has requested in a this is the notice statute, not the delinquencies statute. So notice statute is 6490-515 sub 2 sub B, but when a statute specifically states that notice must be sent to the unit, to an offsite mailing address, and to email, to be compliant, you have to do all three. Even if you are aware that there is no mail receptacle at that location, to comply with the statute, you're going to have to do it anyway. And these are only for specific types of notices, like the first delinquency notice or first foreclosure notice, notice of delinquency foreclosure. So when the statute requires it, you have to do it, otherwise you don't. Valerie, did you have anything to add to that?
Yeah, I just want to clarify that the requirement to mail to both the lot or unit address and an offsite mailing address applies both for the first written notice to the owner of their delinquency, this new notice that's now going to be required in January. It also applies to the pre-foreclosure notices of delinquency. And that's been true for a while. That's been true for a while. And those have to be sent along with the first written notice of delinquency. And then a second copy of the pre-foreclosure NOD has to be mailed to the owners no sooner than 60 days later. So this will sort of roll into another question that we're going to answer next, which is about the follow-up notice frequency. So I'm going to move us into that one now. And it says, if an owner has been delinquent for an extended period, and we sent the required initial notice in 2024, followed by a 60-day follow-up, is any further action needed? If the account remains delinquent with no payments made, are we required to send updated delinquency notices yearly, or are the two initial notices all that is required for ongoing compliance? So there's a couple of different layers to this question. One is, in my opinion, starting January 1st, 2026, there's this new delinquency notice requirement. And it is highly unlikely that the notices that you sent in 2024 or even 2025 complied with this new statutory requirement. And I am going to be telling all of my clients that even for accounts that were delinquent before January 1, 2026, the lowest risk way of proceeding is to send a notice in 2026 that complies with the new statutory requirement. Because what I don't want to do for any of my clients is have a client come to me a year and a half into a delinquency, say that they didn't mail that 2026 compliance notice, and risk that a court might later invalidate a year and a half worth of late fees and interest or whatever else based on a failure to do that. I don't know how likely that is, but most of my clients don't want to pay me to be test cases in court because it's really expensive. So that's one thing that I would say when it comes to this specific new compliance notice that everybody's going to have to send in 2026. Separately from that, the larger question of how often to send delinquency notice when you've got a longer delinquency, a longer standing delinquency is, the best practice is to send periodic notices. And what I would say is how frequently you send them will depend on a lot of factors, right? Not just one thing. So how often are the assessments charged? How much are the assessments? How long has the account been delinquent? How much is the balance due? Have you sent both of the required pre-foreclosure NODs that are required by statute? Excuse me. And what does your declaration and your collection policy say about delinquency notices and the frequency of them? And also, disregarding all of that, the whole point of sending delinquency notices beyond complying with the statute is to put owners on notice of their delinquency in the hopes that they will make payments until they get caught up. And less frequent or minimal, bare minimum notices are not going to accomplish that goal. So you want to demonstrate as well in the future to some court in a year or two or five that's looking back and trying to evaluate the reasonableness of your actions as an association. You want to be able to demonstrate that you acted reasonably and proactively to give the owners an opportunity to cure the delinquency, to pay their account before you took legal action that added thousands of dollars to their balance due. So the short answer to this question is that we cannot give one size fits all advice on this question because of the variation in assessments, the types of communities, the amount of the assessments, the frequency with which they're charged, all of those things. But I think you should at least send periodic notices. So I think if an account, so for example, if an account is referred to me that fell behind in 2024, which is now, a year and a half, maybe more ago, just depending on when in the year it fell behind, and they sent two delinquency notices back in 2024 and crickets ever since then, I'm telling my client to send another notice before I record a lien and send a demand letter, unless there's a reason for urgency in terms of getting the legal process going. Because the last thing that I want to do is send a demand letter and then have the owner be like, what are you talking about? I had no idea I was delinquent. I haven't received anything from the community in 18 months. How was I supposed to know my account was still behind? That's not a super strong legal argument, but it's a complicating factor that I would like to avoid. Um, Keep in mind also a couple of other considerations. One is that there is a statute of limitations on collecting unpaid assessments. For condo associations that are not under Wakaiowa, that statute of limitations is 3 years. For HOA Act communities and Wakaiowa communities, the statute of limitations is 6 years. But I would never, ever, ever, under any circumstances, recommend that you wait until you get close to the statute of limitations before at least evaluating with your attorney your legal options to collect on a delinquency. One of the things that we have learned in handling thousands now of delinquencies over the course of 20 plus years is that the lower the balance due is when we get involved, the shorter in duration the delinquency, meaning you send it to us within 90 days or 6 months of delinquency instead of a year or 2 years or 5 years or whatever, the more likely we are to be able to negotiate a successful payment plan with the owner, the more likely the owner is to respond to things like letters or an email versus ignoring everything because they're in financial trouble and have been for 2 or 3 or 5 years, whatever the case might be. So the sooner you send it to us in the delinquency process, the lower the balance due is when you send it to us or to your association attorney, the more likely we are to be able to resolve the delinquency without having to resort to litigation. So I think that covers the question. If you have, follow-ups, feel free to put them in the chat. And otherwise, I'll hand it back to Jen for any comments you might want to add or just jump into the next question.
I think you covered it. Our next question is regarding architectural requests. What is the best way to ensure that a buyer for a unit for which the change may have been granted, example, a heat pump or an extra railing requested by an elderly person, so the buyer knows about the changes or that they would be responsible for any fees as a result of the change, such as having to move it when time to paint or resurface the balcony where a pump may have been placed? Would putting it with the resale certificate do that? Or is there another method? We want to ensure a potential buyer is aware of the change and the condition placed on the original owner. So the best way that we're aware of to put the current and any potential future owner aware of a modification and their responsibility for a modification is what we call a hold harmless agreement. It's basically an agreement signed by the association and the owner at the time that lays out the responsibility for that particular component and also can shift responsibility for damage arising from installation, use, maintenance, repair, replacement of that particular component. So it's a document made to memorialize all of the agreements made between the association and the unit owner, which should include responsibility for moving things like a heat pump while a deck is recoded. Such an agreement might or may not require removal of some modification when an owner moves. The caution on requiring an owner to remove a component, if the modification was made to make a unit more accessible, you may not be able to require its removal. So it honestly depends, but the hold harmless agreement is the best way that we're aware of, and it can also shift responsibility for that component differently than what is contained in your governing documents. So if you put a modification in a resale certificate, that is enough to put a new owner on notice that this modification is in the unit and was approved by the association. But it doesn't necessarily allow the owner to understand their responsibility for that particular component. So it's not a notation on the resale certificate is not effective to shift responsibility for damage unless that is already in your governing documents. And we've had this happen in several communities where the association had an in-house hold harmless agreement or an agreement with the owners that the owners would sign and the association would keep on file. 15, 20 years later, a lot of those agreements were misplaced, lost, had never been signed, etc. And the current board was left with all of these modifications that the association now was responsible for repairing when it should have been the owner, but the documentation was lost over time. When a hold harmless or a maintenance agreement like that is recorded, it's a county record. It runs with the title, it runs with the property, it will be pulled on a title search and is easily found. And the requirement to maintain that particular document doesn't lie with the association, it lies with the county. So, in a nutshell, the hold harmless agreement or a formalized maintenance agreement that is signed by both the association and the owner and recorded with the county is the best way to memorialize any agreements regarding modifications. However, if this is a request for a reasonable accommodation or an accommodation under the Fair Housing Act, speak with your association attorney because the rules are different. Valerie, did you have anything to add to that?
No, I think you covered it. All right, this is our last question that was submitted in advance. So last chance if you want to pop any questions into the chat. Otherwise, we might end up finishing up early today. The question is, can you confirm if we would need physical signatures of two directors or a policy in place that would allow two directors to approve a reserve disbursement? And this is about RCW 6490-535 subsection 3A, which says, except for investments and transfers between separate reserve accounts held by the same association, every disbursement of reserve funds requires the signature of at least two persons who are officers or directors of the association. Of course, as with anything, our starting point is that when the statute is clear, you have to follow the statute, right? But I think there are ways in which this statute is not super clear, and certainly common practices within the industry are not always clear in their compliance with or following these requirements. I'll start by saying that the intent of the statute is very clearly to protect association funds, to make it so that one director or a manager without a director's signature can't just abscond with money that's in the association's reserve account. But we have questions about certain things that are drafted into the statute. So for example, does it define disbursement? And I do not think that it does. So part of what my question would be is, does this include writing a check? Does it include moving the money from a reserve account into the general fund to write a check for maintenance of a reserve component? The other things that I have questions about include things like, are electronic signatures as good as physical signatures? Are we talking about writing a signature on a paper check, or is an email approval from two directors to the manager authorizing them to issue payment from the reserve account good enough? So I think, as you can see, that we have more questions than we have answers. We understand that it is very common practice in the industry that the reserve account is administered by the management company, even though they only do that at the direction of the board of directors. And we also note that the banking industry does not check to confirm if there are two signatures on every check. So the statute says that the signature of at least two directors or officers are required in order to disperse money from the reserve account. But I think we have more questions than we have answers in terms of what exactly that means. If an association is interested in determining what kind of policy it should adopt to make sure that it's in compliance with the statute, I think, the answer to that question is that they should ask their association attorney for a policy that can be used in conjunction with their management company to determine how best to administer the reserve account in a way that's consistent with the statute. So I know that's not a clear answer, but we don't always have those, unfortunately. So I think that's all I've got for that one. And let's see if we have, please enter that statute to the chat. Did you beat me to that, Jen? You did.
Yes, I did.
Okay. It looks like we have one other question in the chat, and I suspect that this is going to be too specific for us to cover, but let's see. How does a board protect themselves when board members start ignoring the law, such as having meetings without notice to owners or not making sure some things are done as required by law, such as having a reserve study done. There are usually no volunteers running for the board for some years, and those we get only do so for a few months after the choice of going into receivership. These things happen even after informing the few board members what needs to be done. I think that's going to be too specific for us to cover here. I will say, if you go to our YouTube channel, which was linked in the chat early in the Q&A today, we have covered the question of boards acting outside of their authority, the struggle to get enough volunteers to serve on the board, and what options owners might have if they believe their board is not acting in good faith. We've covered those topics dozens of times since we started doing this Q&A. So you're welcome to go click the YouTube link and look through some of our old videos and see if there might be something there that is helpful to you in this scenario. Looks like we have one more question in the chat. If a homeowner requests copies of meeting minutes by mail and the association provides copies of all meeting minutes on a homeowner portal and provides them by email, are they required to send them by mail upon request? I don't know that. I think probably no most of the time. But I don't want to say that that is always going to be true. I will say this. An association does have the right to recover reasonable costs associated with responding to a records request. So if an owner, submits a request for like 2 years worth of board meeting minutes and they want you to send them hard copies by mail, I think it would not be unreasonable for an association to say, we have those, they're all on the portal, here's the link, here's an attached copy to my email to you. If you would like paper notices sent by mail, the cost is going to be, and then give them the reasonable cost of printing and mailing those 2 years worth of board meeting minutes. This is, of course, commentary given in a vacuum, so I can't say that that would be reasonable in every situation for every owner, depending on, what type of dispute or situation that you might be dealing with. So, please do remember this is general commentary and not legal advice for any specific situation. Jen, did you have anything different or additional you wanted to offer on that one?
Not necessarily. And kind of flipping from the opposite. If you only have certain records in paper and an owner is asking for electronic copies, you do have the authority under the record statutes to charge them for scanning and charge them for the time used to put those records into the medium that they request. So typically you do not have to provide records in the medium requested if that's not how they're normally kept. But you can do that, and we would recommend doing that for as long as you charge your reasonable costs. It's just courtesy and a way to prevent an owner from going to court, or heck, we have two issues with the Human Rights Commission about an owner making a specific request as an accommodation. So when in doubt, contact your association attorney, but generally, if it's already on the portal, you can point them to that. If it's sent through email, you can point them to the email or resend it. If they're specifically asking for records in a particular way, you can give them the reasonable cost for reducing those records to the form requested. So, yeah, there was another question that Valerie handled.
Yeah, there was a question in the chat about whether the Wakaiowa section on reserve accounts is valid for all communities at this time. And the answer to that question is that it is not. It's only applicable to Wakaiowa communities until January 1, 2028, when we will all be Wakaiowa communities. Until then, if you want to know what your governing statute says about reserve studies, you can Google your governing statute and reserve account. You can Google your governing statute and the words reserve account and go to the section of your particular statute that pertains to reserve accounts and how they have to be administered.
And I would remind people that are an Old Act condo. Old Act is any condominium that the declaration was recorded before July 1st of 1990. Certain provisions of the new act, which is 6434, apply to you, and the reserve study and reserve account is one of them. The legislature didn't want to amend 6432, which is the old act, to add those provisions, so they just made that applicable to you under 6434010.
I think that brings us to the end of our questions for today. So we are done. And my dad would scold me if I missed the opportunity to tell you all that I'll see you next year. Have a happy holiday season. Thank you for joining us, and we'll be back here in a couple of weeks. Bye,
Happy
everybody.
holidays.